A judge just signed a search warrant for your home. Does that mean police can open every drawer, every box, and every room they want? Not necessarily. Here's the thing most people get wrong about search warrants. They assume a warrant is like a blank check, that once a judge signs off, officers can tear through your entire life looking for anything and everything. But that's not how it actually works under the Constitution. A search warrant has limits, and understanding those limits can completely change how you think about what happens when police show up at your door with one. So let's start with the basics. The Fourth Amendment to the U.S. Constitution protects people from unreasonable searches and seizures, and it specifically says that warrants can't just be handed out on a whim. A warrant has to be based on probable cause, which is a legal phrase that basically means there's a fair probability, backed by specific facts, that evidence of a crime will be found in a particular place. It's not proof beyond a reasonable doubt. It's not even close to that. It's a reasonable belief supported by real information, not a hunch. To get that warrant, a police officer typically has to go in front of a judge or magistrate and lay out, usually in a written statement called an affidavit, exactly why they believe evidence exists and where they believe it is. The judge reviews that information and decides whether it meets the legal bar. If it does, the judge signs it. If it doesn't, the judge can deny it. This is one of the core protections built into the Fourth Amendment, an independent judge acting as a check on police power, rather than officers simply deciding on their own that they have the right to search your property. But here's where it gets interesting, and where a lot of the confusion starts. The Fourth Amendment doesn't just require probable cause. It also requires that warrants describe with real specificity the place to be searched and the items or persons to be seized. That's not a minor technical detail. That requirement, often called the particularity requirement, is actually one of the most important limits on how far a search can go. Think about what that means in practice. A warrant isn't just a generic permission slip that says, search this person's stuff. It has to say, essentially, this specific address and these specific items police are looking for. And that description shapes everything about what officers can lawfully do once they walk through the door. Let's use a hypothetical to make this concrete. Imagine a warrant is issued for a home because investigators have probable cause to believe there are financial documents inside related to a fraud investigation, specifically paper records hidden in a home office. The warrant authorizes officers to search the house for those documents. Now, does that warrant let them search literally everywhere? Not exactly. It lets them search anywhere in that home where those documents could reasonably be found. That could include a home office, filing cabinets, desk drawers, even a bedroom closet if there's reason to believe someone might store paperwork there. But it likely would not extend to something like tearing open a small jewelry box because paper files being sought in this scenario wouldn't reasonably fit inside a container that small. The scope of a lawful search is tied directly to what officers are looking for and where that type of evidence could plausibly be hidden. This is actually one of the clearest ways courts have explained the limits of a warrant. If police have a warrant to search for something large, like a flat-screen television, they generally can't justify searching inside a tiny drawer or a small medicine cabinet because a television obviously can't fit there. But if the warrant is for something small, like drugs, jewelry, or a weapon, officers may be justified in searching much smaller spaces because that kind of evidence could reasonably be hidden almost anywhere. In other words, the size and nature of what's being searched for genuinely shapes where police are legally allowed to look. This is actually one of the most misunderstood aspects of search warrants, and it explains why the same warrant can lead to very different scopes of search depending on what's listed on it. Now, here's a related question that trips a lot of people up. What happens when officers make an honest mistake about where they're allowed to search? Here's a real example that the U.S. Supreme Court actually dealt with. In a case called Maryland versus Garrison, decided in 1987, Baltimore police obtained a warrant to search a specific third-floor apartment, believing there was only one apartment on that floor. It turned out there were actually two separate apartments up there, and officers ended up searching part of the wrong one before realizing their mistake. The Supreme Court looked at this and asked whether the search was still constitutional, even though officers technically searched a space the warrant didn't cover. The court held that the search was reasonable because the mistake was an honest one, based on the information the officers reasonably had at the time they got the warrant, and because they stopped searching the wrong apartment once they realized what had happened. This case shows something important. The legal standard isn't perfection, it's reasonableness, based on what officers knew and did at the time they did it. That doesn't mean any mistake is automatically excused. It means courts look closely at whether the mistake was genuinely reasonable given the circumstances, and whether officers acted appropriately once they became aware of it. Let's shift to another common misconception, this one about people, not just places. Suppose officers have a valid warrant to search a specific address, and when they arrive, there are other people present in the home who aren't the target of the investigation. Does the warrant to search the property also give police automatic authority to search those other individuals? Generally, no. A warrant to search a particular place does not automatically extend to searching the people who happen to be there. This actually came up in a real Supreme Court case called Ybarra versus Illinois, decided in 1979. In that case, police had a warrant to search a bar and the bartender based on suspected drug activity. While executing that warrant, officers also patted down and searched a customer who happened to be in the bar at the time, even though there was no individual, particularized reason to suspect that specific customer of anything. The Supreme Court held that the warrant to search the bar and bartender did not, by itself, justify searching every person inside. Officers generally need some independent, specific reason related to that particular individual before they can search a person who merely happens to be at a location covered by a warrant. So the lesson here is that a warrant is tied to what it actually authorizes: a place, certain items, or specific individuals identified in it. It's not a blanket authorization to search anyone unlucky enough to be standing nearby. Now, let's talk about what happens when officers go beyond what a warrant actually allows. Suppose, going back to our earlier hypothetical, that officers with a warrant to search for paper financial records instead start opening a small jewelry box, and inside they find something completely unrelated, say illegal drugs. Is that discovery automatically usable as evidence? This is where a concept called the exclusionary rule comes in. The exclusionary rule is a legal principle that says evidence obtained through an unconstitutional search generally cannot be used against a defendant in court. Its roots go back to a landmark Supreme Court case, Mapp versus Ohio, decided in 1961, which held that evidence obtained in violation of the Fourth Amendment can't be used in state criminal prosecutions, extending a rule that already applied to federal cases. If a court determines that officers searched somewhere the warrant didn't authorize, evidence found as a result of that overreach can potentially be suppressed, meaning a judge excludes it from being used at trial. But, and this is important, exceeding the scope of a warrant doesn't automatically mean the entire case falls apart, and it doesn't automatically mean every single piece of evidence gets thrown out. Courts look closely at exactly what happened. If some evidence was found lawfully, within the proper scope of the warrant, that evidence can often still be used, even if other evidence, found through an improper search, gets gets excluded. There are also exceptions that can allow improperly obtained evidence to still be admitted in certain circumstances, such as when officers would have inevitably discovered it through legal means anyway, or when they were relying in good faith on a warrant that later turned out to be legally deficient through no fault of their own. These are genuinely complicated, fact-specific legal questions, and how they play out depends heavily on the particular circumstances of each case and the jurisdiction involved. There's another important concept worth mentioning here, called plain view. If officers are lawfully present in a location, whether under a warrant or another legal basis, and they come across evidence of a crime that's clearly visible, out in the open, they may be able to lawfully seize that item, even if it wasn't specifically listed in the warrant. But this doesn't erase the particularity requirement. It applies narrowly when officers are already legally where they're supposed to be and immediately recognize something as evidence, not as a workaround to search areas the warrant never covered in the first place. So let's bring this back to our original scenario. A judge signs a search warrant for a home. That warrant does not automatically mean police can search every inch of the property without limitation. What they can search depends on what the warrant specifically authorizes, the items or evidence described, and where that type of evidence could reasonably be found. Officers generally cannot search areas or containers that couldn't plausibly hold what they're looking for, and a warrant for a location doesn't automatically extend to searching every person who happens to be present. If officers do exceed those limits, evidence obtained improperly may potentially be challenged and excluded. But that process is complicated. It depends heavily on the specific facts of what actually happened, and it doesn't automatically mean an entire criminal case disappears. If you ever find yourself in a situation where police are executing a search warrant, the most important thing is to remain calm, avoid interfering with officers doing their job, and understand that these legal questions about scope and validity are exactly the kind of issues an attorney can evaluate afterward, based on the specific facts of what actually happened. Understanding the limits of a warrant is really just one piece of a much bigger picture about how searches work in this country. If you've ever wondered what your rights actually look like the moment police show up without a warrant at all, that's a completely different set of rules, with its own exceptions and its own protections. And it's worth understanding just as clearly as this one.